What if your family green card application in 2026 faces tougher interviews, deeper background checks, social media checks, and higher denial risks? New updates suggest family-based cases may face stricter scrutiny than before, with tighter marriage reviews, stronger financial checks, and longer processing delays. In this video, we break down the 2026 immigration changes, why USCIS is increasing scrutiny, and what families should do now to avoid mistakes and delays. Hello, everyone. Welcome back to our channel, U.S. Immigration News. A tougher immigration system may be coming. If you are planning to apply for a family-based green card in 2026, immigration experts are warning about a major shift that could make the process far more difficult than before. While Congress has not passed a brand new immigration law yet, U.S. immigration agencies are expected to introduce stricter scrutiny, deeper investigations, and tougher evidentiary standards across almost every stage of the process. The biggest news change for 2026 is not a complete overhaul of family immigration, but a stronger enforcement approach by USCIS and the Department of State. Officials are preparing to increase fraud prevention efforts, strengthen security vetting, expand interviews, and carefully review financial sponsorship requirements. For many families, this can mean longer wait times, more requests for evidence, additional interviews, and a higher risk of delays or denials. USCIS expected to intensify background checks. One of the most important updates expected in 2026 is enhanced vetting for family-based petitions. Immigration officers are likely to perform much deeper investigations into applicants and sponsors to confirm that relationships are genuine and all information provided is accurate. USCIS may now cross-check immigration records, travel history, tax filings, employment records, prior visa applications, and government databases more aggressively than before. Applicants with previous visa overstays, immigration violations, or inconsistent information across forms may face increased scrutiny. Even small mistakes or incomplete disclosures could trigger concerns about misrepresentation under immigration law. Officials are also expected to increase watch list screenings and national security reviews during the adjudication process. Marriage and fiancé visa cases could face the strictest review. Marriage-based green cards and fiancé visa applications are expected to receive some of the toughest scrutiny in 2026. Immigration officers may conduct more detailed interviews to determine whether relationships are legitimate. Couples could face expanded questioning about their relationship timeline, daily routines, finances, family connections, and living arrangements. Applicants may also be required to submit stronger relationship evidence, including joint bank accounts, shared leases or mortgages, utility bills, joint insurance policies, wedding photographs, travel records, joint tax returns, affidavits from family and friends, communication records. USCIS officers may even re-interview applicants if they believe additional clarification is necessary. There are also reports suggesting that officers may increasingly review public social media activity and conduct site visits to verify whether couples genuinely live together. New fraud detection systems are expanding. Another major development for 2026 involves expanded fraud detection protocols inside USCIS. The agency is expected to rely more heavily on advanced data analytics to flag suspicious cases. Applications showing unusual filing patterns, rapid relationship timelines, or inconsistencies between forms may automatically receive closer review. For example, if a sponsor files multiple petitions for different relatives, USCIS may evaluate all related cases together to search for inconsistencies or possible fraud indicators. Cases identified as higher risk may be referred to fraud detection and national security units for additional investigation. Because of this, applicants should expect more requests for evidence, more notices of intent to deny, and stricter reviews of incomplete records. Financial sponsorship requirements are also expected to become stricter in 2026. Immigration officers will likely apply more rigorous reviews of affidavits of support to ensure sponsors can financially support immigrant relatives without government assistance. Officers may closely examine recent tax returns, W-2 and 1099 forms, pay stubs, employment verification letters, bank statements, asset documentation, household size calculations, joint sponsor qualifications. There is also growing discussion about a broader interpretation of the public charge rule. This rule evaluates whether an immigrant may become dependent on public benefits in the future. As a result, applicants may need stronger financial evidence and backup sponsorship options before filing. More interviews and longer processing delays expected. Another major impact of these stricter policies is slower processing times. Because officers are expected to conduct more interviews, additional background checks, and expanded fraud investigations, family-based green card applications could take much longer to process in 2026. Administrative processing at U.S. consulates abroad may also increase, creating unpredictable delays for immigrant visa applicants. Families may experience delayed interview scheduling, longer USCIS processing times, additional requests for evidence, extended security checks, more in-person interviews, delays in work authorization approvals, travel complications during pending cases. Post-to-post variations at U.S. consulates may also create inconsistency, meaning some applicants could face tougher reviews depending on where they apply. Small errors could create serious problems. One of the biggest concerns for 2026 applicants is that even minor inconsistencies may trigger major scrutiny. Differences in addresses, employment history, travel dates, tax information, or previous visa applications could raise questions about credibility. Immigration officers are expected to apply stricter standards when evaluating incomplete answers or conflicting information. Misrepresentation findings could potentially lead to denials or future immigration consequences. Because of this, applicants must carefully review every form before submission. How families should prepare for 2026 applications. Experts recommend that families begin preparing early and organize documents carefully. Applicants should build strong evidence packages with detailed relationship documentation and fully updated financial records. Sponsors should validate income using recent tax returns, pay statements, employment letters, and asset proof. Families may also want backup joint sponsors ready in case additional financial evidence is requested. Applicants are encouraged to review prior immigration filings, social media accounts, and travel history for consistency with current applications. Many immigration attorneys also recommend practicing mock interviews and preparing clear timelines explaining the relationship history. Final thoughts on the 2026 green card changes. Family-based immigration will continue to exist in 2026, but the process is expected to become far more demanding. The biggest news change involves stricter enforcement, expanded fraud detection, enhanced background checks, tougher financial reviews, and increased scrutiny of relationship evidence. Although the core immigration laws may remain the same, agency discretion and operational policies could significantly affect approval outcomes. For families hoping to reunite in the United States, preparation, accuracy, and strong documentation may become more important than ever before. Okay, that's for today's video. Thanks for watching, and we'll see you in the next video.